All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument this morning. First, in three consolidated cases, 19-612 and 21-159, Mosaic Baybrook versus Simeon from Harris County and the First District Court of Appeals. And the third case with those two is 21-161, also Mosaic Baybrook against Cessor, also from Harris County and the First Court of Appeals District. Court has allotted 30 minutes for each side in those three consolidated cases. And then second will be 2980, Wal-Mart against Xerox from Dallas County and the Fifth Court of Appeals District. Court has allotted 20 minutes per side in that case. Justice Lehrman is not participating in the argument in that case. We're ready to begin. The arguments will be live cast this morning and will be available on the court's website later today. And of course, we'll finish the arguments this morning. So we're ready to begin with the first three consolidated cases.
May it please the court, Mr. Russell will present argument for the petitioners. Petitioners have reserved 8 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, I'd like to focus my time on two primary issues today. First, Simeon's water code claim fails on the merits because mislabeling non-water fees for fire, EMS, and law enforcement service is neither an injury in law nor an injury in fact. And for the same reasons, the class must be decertified as being based upon a significant misunderstanding of law, just like in Exxon versus Gill. Second, Cessor's late fee claim likewise must be decertified as another example of certify now and worry later, which was rejected by this court in Bernal. And the Court of Appeals' conclusion that, quote, an elaborate analysis is unnecessary directly contradicts Bernal. And the Fifth Circuit's opinion in Cleveland provides a perfect example of what a rigorous analysis of Section 92.019 would look like in a proper class certification order, something we simply don't have here. So returning to the first issue, the trial court erred in granting the partial summary judgment on liability under the Water Code. The first place to look, of course, is the text of the Water Code. And the text have that as well as some of the relevant sections. Section 13.505 of the Water Code is in our bench book exhibit 7, and also some of the PUC rules. So looking at the text itself of the liability implementing provision, section 13.505, it's clear that the only rule violations that can potentially lead to an overcharge that creates liability for an overcharge are those charges for utility service, specifically here for allocated billing, non-submetered, master metered utility service costs.
Well, so it says it violates a rule regarding those costs.
Right, and I think my friend on the other side reads regarding a little bit broader than we do, but it's still specific to utility costs, and utility is the defined term in the Water Code to only meaning drinking water and wastewater. And of course, we know as a matter of fact and law, these charges for fire, EMS, and law enforcement are not charges for water, drinking water or wastewater.
But also part of that was a water and sewer service charge, right? part of that bundled water sewer base fee was not only the 3 emergency service fees, but also a water sewer service charge?
Yeah, there's a MUD service charge, a customer service charge, and the PUC rules actually expressly permits that, and so they disclaim that in their petition. Simeon's petition disclaims any liability on that
But it
charge.
was bundled together with the other 3 fees.
It was, but again, they're not complaining about the bundling, they're complaining about those 3 charges for EMS, fire,
But it
fire and
seems
law.
relevant as to whether there was an overcharge. If there's 1 fee that everybody agrees was proper, that's part of that bundle, and 3 that don't fit under the description that was provided to the tenants, why isn't that an overcharge?
A number of reasons. First, I think there's a distinction between the form and the substance. Substantively here, the PUC rules, particularly the best example, I think, is in the code section, the rule section for underbilling and overbilling. And it says if a bill is issued and subsequently found to be in error, then there can be both an undercharge and an overcharge. And when there's an undercharge situation, the landlord, subject to certain qualifications, like only going back 6 months, is entitled to get reimbursement from the tenants for undercharges in the event of an error. And here, it was certainly an error to describe what was not water-related fees as a water sewer base fee. So again, that's a matter of form over substance. And we don't think that that is an overcharge. Their position is if you misdescribe something that is not a water-related fee, as though it were, that creates liability. But there's nothing in this statute that's anything like the DTPA.
Well, what about in 13-50313, it says an owner or condominium manager may not impose additional charges on a tenant in excess of the actual charges imposed on the owner for utility consumption. And then again, in the relevant rule, charges billed to tenants for the utility service may only include bills for water or wastewater. So what the statute and the rules seem to be focusing on is how were the charges billed or how were they imposed? And in this case, it seems like they were billed and imposed as water sewer charges, even though some of them weren't.
They were described as though they were
Okay,
for...
but help me with how do we interpret the word imposed and billed in the statute and rule? What do those mean? I hear you using the word described. Is that the same as billed?
Billed, we think, as we talked about in the brief, is simply it's an adjective. It's a past participle describing as an adjective describing what charges we're talking about. So we're talking about those that are billed to the tenant as opposed to some other charges that isn't billed to the tenant.
What about imposed?
Well, I mean, I would agree that they were certainly imposed. It's a question about is that I think if you look back at that section the court, Your Honor, just referenced, section 13.50313, is talking about an excess amount. And I don't think anyone would describe fees for a service that are unrelated to water as an excess. It's simply a different category of fee altogether, and that's why the rule, the prohibited charges rule, if you look at it in
well,
context.
but it talks about charges imposed on the tenant and then charges imposed on the owner. So certainly you're correct that it's not the emergency service charges are not charges imposed on the owner, your client, for utility consumption, but they were, it seems, imposed on the tenant as charges for utility consumption, even though they weren't.
No, to be clear, the MUD charges for fire, EMS, and law enforcement are imposed on the landlord. And then the landlord, and they're charged on a per unit basis as opposed to an allocation formula like water usage charges are. So we then, pursuant to nothing in the water code subchapter M, there's nothing in there that simply talks about those kinds of charges expressly. And we're certainly not included in the list of express prohibited charges. So the deposit, the disconnect, the reconnect, the late fees, and the other similar charges that are referenced in the prohibited charges rule of the PUC rules, I don't think you can reasonably include in that list applying the justum generis doctrine. I don't think you can include in that list fire, EMS, and law enforcement charges. So again...
Right, I agree with you on that. I guess my question is, why shouldn't we read that rule as having 2 clauses? The first one says, charges billed to tenants may only include bills for water or wastewater. and then it says, and must not include these other things. It seems to me like one way to read that is that the second clause is a carve-out of things that might otherwise be thought to fall under the first clause. But I think you're correct that fire, EMS, and whatever the other one was, the emergency service charges would not be read to fall under the first clause. And so then we have the problem that they were billed as that, even if they don't actually fall within water or wastewater bills from the retail public utility.
Well, I think maybe a hypothetical would help. I mean, it's clear that nothing in the PUC rules or the water code addresses, permits, excludes, prohibits a rent charge. But I think the misdescription of the non-water charges here, these emergency services charges here, would be very similar to if we had called the rent charge I had an example here, a water use apartment occupancy fee. I mean, I think that's pretty consistent with what rent is. When you rent an apartment, you have the right to occupy the apartment, you have the right to use the water, and if we put on the bill, instead of the word rent, we said water use and occupancy, apartment occupancy fee, their position would be, and I think unreasonably, that somehow is a violation of the PUC rule that we've been talking about, because it is billed as though it were a water-related fee, but is not. And so we think without the language that we see repeatedly in the DTPA, which does prohibit deceptive, misleading, inaccurate, and false statements about what services are being provided, that we don't have any of those terms in this subchapter M of the Chapter 13 of the Water Code. So I don't think that the concern that the legislature had in this chapter was about mislabeling, whether inadvertent, whether unintentional. It was about, are you charging an excess amount of actual usage charges? That's prohibited. And just so the court's clear, in the PUC rules, we get the bill from the retail public utility, in this case, which was the MUD. We have to absorb the first 25% of that bill, which I presume is for purposes of filling up the pool, landscaping, those kinds of issues. The other 75% we can then allocate using the PUC, one of 5 PUC formulas. So what was the concern here with this regulatory scheme was that if we didn't absorb that first 25%, or let's say we did, and so we properly we allocated 75%, but we did it inconsistent with one of the PUC formulas, then that would be a problem. Or if we charged, we paid the bill late to the MUD and they assessed a $1,000 late fee, and we decided, well, we don't want to absorb that, let's pass it along to tenants, no one will know. Those are the scenarios that I think the PUC, when adopting the rules, was trying to protect against.
So does that argument that you can charge these costs another way depend on your being right about the interpretation of the lease?
I don't think so. The lease simply goes to whether there's a contractual right for us to decide, for the parties to agree, you're going to be responsible tenant for these government service fees, as opposed to the landlord. So if we had said, no, we're going to cover the government service fees, and then we charge them instead to the tenant, that would be a violation of the lease. I don't think it would be a violation of the water code.
But what you say is this is not a violation of the water code because we could legitimately charge them. These fees, we just mislabeled them. But doesn't that depend on your being right that you could in fact charge these under the lease?
Again, I don't think so, because they're two different issues. One's a breach of contract issue. One is whether there's an overcharge. And I think it's clear, and I'm not sure I made this point before in our prior discussion, which is the rule contemplates there can be violations of utility costs that don't result in an overcharge at all.
So it's just fine with you if we assume that you couldn't charge this under the lease?
I think so. Now, I think we can, and I'll be happy to discuss why we do believe we were entitled to charge it pursuant to the contractual agreement of the parties. But if we violated the lease, that isn't necessarily a violation of the water code. And of course, the only claim that's been certified and the only partial summary judgment ruling, and frankly, the only claim that's been asserted in this case so far, is a breach of the water code provision and liability under Section 13.505. And
Can I turn your attention to the other two class certification appeals, and in particular, the Fifth Circuit in Cleven said that in that case, predominance issues required statutory interpretation to inform whether there was predominance there. Is statutory interpretation necessary to a predominance consideration in either of the two class certification appeals in these cases?
I think it is, but not only is it relevant to predominance, it's relevant because the Supreme Court, this court's authority on what is required in rigorous analysis is different and broader, and I think a little bit more strict. And we can see that first if you look at a comparison side by side of both the Texas rule versus the federal rule, which I have in tab 4 of our bench book. The whole scheme of requiring listing the elements of the claims and defenses is unique to the Texas rule. There is no subpart C1 capital D in the federal rule, and the Romanet 8 of that rule is the rule that is essentially codifying Bernal, and that is if a class is certified, the court's order has to say how the class claims and any issues raised by the claims or defenses asserted in the pleadings will be tried. So you certainly have to know, do we have a valid claim here based upon a correct understanding of the law before you even get to the questions which are...
So do you agree that you do not have to make a decision on the merits in connection with making a decision to certify the class, or do you think that you have to make a decision on the merits?
Well, that depends on what you mean by decision and what you mean by merits. And so first of all, our position is that analyzing the merits is quite different from deciding the merits or adjudicating the merits. So we don't think you have to adjudicate the merits, but you have to analyze them. And then the next question is, what does merits mean? Merits doesn't mean...
So no, you do not have to reach a decision.
No, you don't have to reach a decision.
Okay, so what beyond sort of listing the claims and defenses do you think? Is it something like probable right to recovery? What is it? What is the standard that you have to meet and in order to certify the class?
I think the Cleveland opinion breaks out the two propositions of law that are closely related but different. So the issue of rigorously analyzing the claims and the defenses and understanding the law for purposes of informing whether the prerequisites are met is a separate and distinct issue of if you have certified a claim that is based upon a misunderstanding of law. And so if you look at the Amgen
there
case...
was a summary judgment that had been granted, and so the court had already done that interpretation as a separate part of the merits, which is not the case in Cessor, as I understand it. There was not a motion for summary judgment.
Correct.
On the late fee issue. So maybe you can help me understand, what do you need, if you're challenging class certification, what do you need to say to the trial court or to the Court of Appeals in order to put them on notice of what you want them to do a rigorous analysis of? It seems like, I read your brief in Cessor and it says that a rigorous analysis wasn't done, but I didn't see anything indicating how the analysis should have been different on any of the particular certification requirements, such as predominance or commonality, typicality. Do you have some obligation to say either to us or to the trial court, not only do you need to do a rigorous analysis, but if you had, here's how it would have been different?
No, we don't, because it's the plaintiff's burden to prove that the class prerequisites have been met, that Rule 42 analysis has been done, and then ultimately it's the trial court's obligation to have conducted it, and that obligation has to be demonstrated.
Okay, but then on appeal, when the class has been certified, don't you then need to come to us and say, here's where the error is?
All I have to show, just like as was shown in Gill and this court found in Gill, is that in leading up to what would have been analysis of whether there's predominance, typicality, that if there was a legal error on the way there, and that's why I wanted to make a distinction between what kind of merits are we talking about. Are we talking about a merits issue that leads to adjudication? The Amgen case was a merits of materiality, and the issue was a matter of did you prove materiality, and the argument to avoid class certification there was you have to prove materiality before a class can be certified, and I agree that's wrong. But there's a difference between saying there's a failure of proof and saying as a matter of law, based upon undisputed facts, which we have in Simeon, you have certified a class based upon a misunderstanding of law. And I think it is always an abuse of discretion to certify a class on a misunderstanding of law when it's a substantial misunderstanding of law.
But
because
I guess I didn't see in your brief in Cessor where you argued what the misunderstanding of law was.
Okay, well, in Cessor, as I said in opening, is different. So Simeon is an example of a misunderstanding of law certification. Cessor is, we haven't done any analysis of what the claims would be, how they would be, what the defenses are, and what the substantive issues are. So that's an example of certify now, worry later.
Well, but I guess what I'm trying to understand is I don't know that it would be helpful for us to send something back to the trial court saying do more analysis if we don't know, A, in what particulars their analysis fell short this time, in Cessor I'm talking about specifically, and if we don't know that the outcome would be any different. Is there any concept of sort of harm here where, and why or why not? I mean, if it turns out that the analysis would have been just the same if the outcome would have been just the same if they'd done more analysis, it doesn't seem like an efficient use of time to send it back.
I think the opinion in Yarbrough that Justice Lehrman wrote answers that question. The court there said, we don't know how this will come out. It may very well be, and I'm paraphrasing, it may very well be that the class will be a valid certified class, but we do require the trial court to conduct it. So if the court hasn't conducted any analysis, right or wrong, then this court's obligation to send it back, because then there's nothing for this court to review. And that's exactly what the court did in Gill. They found, well, Gill's a little different.
I can go back and look at the briefing in Yarbrough, but it seems to me it would be helpful for us to know in what particulars and with regard to which particular requirements of class certification you think the analysis is deficient.
And also, in answer to Justice Bland's question, I think the question is, what is the standard to say, that there's a difference between an analysis and a decision? It depends on what you're saying with regard to that, but decisions are based upon different things depending upon what stage of the game we're at. And so what is it here?
Well, the standard is simply to show that you've done some rigorous analysis. And when we're talking particularly about a statutory claim that's never been construed before by any state appellate court, I think at a minimum, what needs to be in the demonstrated order, the class certification order, needs to be a demonstration of not only that the trial court understands the claims and the defenses and the substantive law. So there would at least have to be some analysis like there was in the Cleveland Fifth Circuit opinion about what does the statute mean, and then once you understood what the statute means, then you can get into the discussion of, okay, do we have predominance here? Do we have typicality here? But I don't think you can say, well, we can affirm a class certification order that doesn't even do the analysis, let alone one that does it but does it wrong, which is exactly what happened in Cleveland. They mentioned the word, the Cleveland opinion at the Fifth Circuit mentions the word predominance once, and then it goes on and analyzes and says that it is a necessary antecedent to determining the answer question, the predominance question, to correctly construe the statute. And we don't think here in the Cessor case, the trial court never construed the statute.
Did you ask it to?
No, we didn't, but it's not our obligation to do so. So whether there was a summary judgment like there was in Simeon, or whether there was no, dispositive motion of any sort, the trial court's order can include all of that analysis. So it should go through that kind of analysis in a class certification order that might be similar to the kind of analysis you do in a summary judgment. You got to construe the statute and the elements, but you also then that construction then informs, do we have predominance here? And there was simply nothing.
So the trial court has to do that without any adversary presentation?
It doesn't. I mean, it should do it based upon their briefing, but they were sort of hoping that they could hide behind a log. I think
there's a difference, but one person's hiding behind a log is another person's. There's no dispute about this issue. So how do we know which one it is?
Well, it's their burden to prove all of the prerequisites. It's the plaintiff's burden to prove all the prerequisites. It's kind of like a summary judgment.
But sometimes some of them aren't disputed.
That's true, but how does
the trial court know which one is which?
Well, if they had made an argument that, in fact, they did. I should point out this. In their motion for class certification, they made the argument that there was a prospective analysis required of, I'm about to run out of time, but there was a prospective analysis required before you could assess a late fee. And they argued that, and it's nowhere in the class certification order. That would have been some analysis that was consistent with what they advocated, but it's missing from the class certification order. So if, am I overtime? I'm overtime.
You may finish your answer.
Thank you, Your Honor. So basically, they didn't do that, and we would have, and by the way, that not only was that in their class certification order, it doesn't show up in the, I'm sorry, that was in their motion for class certification. It didn't show up in the order. So it was kind of, you know, what am I supposed to talk about? But we still think that there had to be some opportunity for the court to analyze and construe the statute, and then we could respond and say, well, they're wrong about what they think the statute means and how that plays into these elements, and therefore there was nothing to review and nothing to dispute. But it's kind of like a summary judgment motion. If they fail to prove as a matter of law that they're entitled to a summary judgment, I don't have to do anything. I can just sit back and explain on appeal why that was wrong.
Any other questions? Thank you, counsel. We'll hear from the respondents.
May it please the court, Mr. Post will present argument for the respondents.
May it please the court. There are issues here of class certification procedure, and there is a challenge to the merits of the Simeon case. I want to address both because the jurisprudentially significant issue, it seems to me, is the question about the scope of class certification. I'll begin there, but I want to emphasize that we're not at all reluctant to explain the merits of the liability theory in Simeon and how that's a violation. So I want to be certain that I have enough time to touch on that issue. I want to begin with a proposition that I think should be non-controversial. Rigorous analysis is common ground. The respondents here are not in any way resistant to the doctrine of rigorous analysis. And if you look at the record of the class certification hearings in both of these cases, you will see that the respondents went through a detailed presentation with the trial court that identified the nature of the claims, touched on each element required for class certification, demonstrated the manner in which this record qualifies for class certification, and pointed out that the defendants had not identified any impediment to class-wide adjudication of these cases. And so we are embracing the doctrine of rigorous analysis. Where we part ways with the defendants is their proposition that rigorous analysis requires the trial court to determine the merits of the case as a precondition to certification. That's simply wrong. I think the leading authority on this proposition, because both in Texas and in the federal system, this question about the relationship between the merits and class certification bubbled in the years after 2000 about where do you draw the boundary between the merits and class certification. And it was distilled, I think, most precisely by the U.S. Supreme Court in the Amgen case. And the court there said merits questions may be considered to the extent, but only to the extent, that they are relevant to determining whether the Rule 23 prerequisites for class certification are satisfied. I submit to you that every decision of the U.S. Supreme Court that engages with the merits falls within that rule, and every decision of this court that deals with the relationship between the merits and a class certification ruling falls within that rule.
Does that mean it's a final determination as to whatever that issue was that has bearing upon that preliminary issue?
Well, Your Honor, I don't think it would be a final determination in the technical sense that the court would have prejudged the merits in a particular case, but there are certainly instances where the merits overlap with the class certification requirements. And in those instances, it's absolutely orthodox law that the court has to examine the merits in order to undertake the rigorous analysis necessary to determine whether the class certification prerequisites are met. The class instance here is predominance, because the battle in these cases is ordinarily whether the key issues can be decided on a class-wide basis or will require individualized analysis.
So I understand the notion that we don't want to try the case at the class certification stage, and that's sort of putting the cart before the horse. But when we're not talking about resolution of factual issues or something that looks like a trial, when we're talking about a pure question of law, a motion to dismiss type, legal impediment to the claim proceeding, I understand your view of the rules and the precedent, but as a practical matter, what purpose does it serve to not go ahead and address, let's just hypothesize, a blatant legal defect in the merits of the claim that doesn't require any factual development? Why wouldn't we go ahead and do that at the class certification stage?
This court addressed that question in Intratex versus Beeson, one of the key trilogy of cases that set out rigorous analysis at the beginning of this era of class certification jurisprudence by explaining that if it's a baseless claim, then the class should be certified and it should be adjudicated on the merits to extinguish all potential claims by all possible class members. Because otherwise, you extinguish one potential claim, but you leave a defendant open to the possibility of serial litigation where they're not bound by the original determination. And so it's not form over substance. It is actually substance to say the purpose of class certification is to determine whether it is most appropriate to litigate an issue on a class-wide basis. And then, as the court said in Citizen Company versus Docock, after there's been notice, after there's been an opportunity to opt out, after class members have made a determination whether they wish to commit their rights to the class vehicle, then the merits are to be determined. And so there's a very substantive reason for that approach.
But it just seems that, I mean, if there plainly are no merits, why go through all that?
There are, I think, Your Honor, exceptional cases. And I don't quarrel with the proposition that there can be an exceptional case where a trial court looks at a claim and says, this is a sham claim, and I'm going to dismiss it summarily. And I think that
in the Simeon case, the Court of Appeals did not take the permissive interlocutory appeal on the summary judgment issue.
Correct.
But if we were to take it and say that summary judgment should have been granted, would the appropriate thing to do, would it be to remand the Rule 23 class action to the trial court to determine whether or not the class should remain certified because there was I guess the phrase is basic misunderstanding of the law? What would be the effect of taking the summary judgment issue, which is teed up on this legal issue?
So let me respond by making sure that I begin with one important procedural predicate. The defendants did not move for summary judgment in Simeon. The plaintiffs moved for summary judgment in Simeon and established the liability case as a matter of law. There's not a contrary motion. Now, the answer technically, I think, to Your Honor's question is that because the answer to that question is uniform class-wide, the defendants have never suggested that their position about the correct interpretation of the water code raises any individualized issues. They agree that it's a uniform issue. So there would be no reason in that instance to question the class certification. And I think this speaks to exactly the question you asked of opposing counsel of what is the rule? What is actually the guiding principle? And the guiding principle is cohesion. Justice Lerman, you asked about this as well. Where do you draw the line? The line is drawn at the element of cohesion. Does the application of a particular substantive principle lead to individualized inquiries that defeats class certification, or does it lead to a class-wide adjudication where the entire class wins or loses in one fell swoop?
If overcharge means charging me more than I owe you out of any category, then wouldn't you have to do some kind of a individualized examination of, well, how much did you owe and how much did you owe and what did your bill say and what was this all for?
In some cases you might, but not in this case. And if I may, I'm going to go ahead and use that as an invitation to actually walk the court through the liability theory in Simeon, because I think I can specifically answer the court's question in that context. So if you have my bench exhibit that was presented this morning, I just want to walk through the reason that this water sewer base fee is a violation of the PUC and a violation on a class-wide basis. It applies exactly the same to every class member. If you look at tab B, this is Mr. Simeon's resident account statement for September of 2016. We've highlighted the water sewer base fee. That is the charge that's in dispute. I call your attention to the entry immediately below the highlighted language, which is a water sewer fee. The unhighlighted water sewer fee is the usage fee that is being allocated to residents in accordance with the PUC schedules. The highlighted water sewer base fee is also a component of the allocated utility service. It is to be charged for connections to the facility, and it is allocated on a per unit basis as the PUC rules contemplate. And so the claim here is that the water sewer base fee is an overcharge to every class member in identically the same way, because it is not, in fact, limited only to the water sewer fee that the utility charged to the property, but bundles in other charges. So let me walk you through exactly how that analysis unfolds. There's some discussion about the lease, and so I just want to make sure that this is clear for the court's benefit. If you look at tab C, you will see that there's a specific addendum in which all of these tenants agreed to allocation of their water and wastewater costs. And in paragraph 4, the lease says, these are the allocation procedures in accordance with PUC rules that will be used with respect to water and wastewater, not any other charges. Look at the next page. The next page is the addendum, again, identical in every class member's lease, that relates to allocating services and government fees. If this defendant wanted to contract with its tenants for the right to pass on these other fees, this was the way to do it. If you look at paragraph 3, there's an opportunity to elect to pass through and allocate emergency services fees. That is not elected in this lease or in any class member's lease. And these addenda control. And so there is no right under the contract nor under the law for the defendant to allocate these non-water utility charges to the residents.
So your position is that this was an overcharge, even if overcharge means charging me money I don't owe you?
Absolutely, Your Honor.
But do we need to take their version of what these numbers are and what these charges are as true, because it's a summary judgment for you, and the court below seems to have said, even if they're right about what all these numbers are, it's still an overcharge and they lose.
Yes.
Don't we need to kind of accept their version of what the
we
numbers
do,
represent?
and I invite the court to look at tab D, because you'll see their interrogatory response where they admit exactly these facts. There's no dispute about these facts because they are admitted in the defendant's interrogatory responses. And the bottom response that's highlighted in tab D is where this defendant says the base fee, that water sewer base fee, is comprised of a service charge, the master meter charge, that's the connection charge I alluded to that's part of the allocated utility service, and then the EMS fee, the law enforcement fee, and the fire fee. They've confessed that they bundled charges that the utility code does not permit them to bundle.
My point is, it seems that you got summary judgment under the theory that mislabeling is an overcharge.
Your Honor.
So if the court disagrees with that, do you lose, even if you might end up winning down the road on the argument that, nevertheless, these were charges we didn't owe?
Your Honor, we got summary judgment on the theory that these charges that were bundled are a violation of the PUC rules that prohibits billing tenants for these charges. And let me call attention to the precise language, so I'm directly responsive to your question. This is in PUC Rule 24.124A. It's included in Mr. Russell's exhibits, and it says, charges billed to tenants for allocated utility service may only include bills for wastewater or water from the retail public utility. And so we got summary judgment on the proposition that the law only allows them to include charges for water and wastewater service, and they admit that they bundled under that charges for EMS and fire and law enforcement. They have confessed liability under this statute.
So I think they agree that that's an error, but the landlord argues that it is not an error of the kind that is actionable under the water code, because that is limited to rules regarding non-sub-metered mastered master utility costs, and then that is defined as water utility service that is master metered for the apartment house, and wastewater utility service, and that these utilities are not germane to anything in the water code.
And Your Honor, that is their argument, and I'm just going to be completely candid with the court. I find it legally incoherent. The statute says a violation of a PUC rule regarding these allocated utility services is actionable. The PUC rule says you may not charge for any services except for the water and wastewater charges that the utility passes through to the landlord. They concede that they charge for other services. Their argument that, well, the PUC rules don't refer to the EMS fees or fire fees or law enforcement fees is not a defense, it's a concession of liability.
Is a treble damages, is that what the statute says?
Your Honor, the statute that's applicable to the Simeon case allows treble damages for the overcharge, a 1-month rent penalty, and attorney's fees.
And so that's pretty draconian, you know, and particularly in a class action context that could amount to a lot of money, obviously. And I imagine two different scenarios, right? One is I'm padding your water bill beyond what you owe, and you can show that my water bill should have been $20 and that landlord is padding it just to extract money from you because he has leverage over you and you feel like you got to pay your bill. And that's clearly what this statute is getting at least in part. And you might not be surprised that the law would impose treble damages on somebody who tries to take advantage of tenants that way. The other case is what they say this one is. I know you disagree, but they say this one is mislabeling. It's a clerical error. It's somebody put the wrong lines on the bill, but all of those dollars in the amount you owe are actually dollars that you owe. And so, you know, we're sorry we mislabeled, but you haven't been harmed. We haven't tried to extract anything from you that you don't owe us. Those are two very different cases. And for the outcome of both of those cases to be a multi-million-dollar class action seems like an awfully strange way for the law to operate.
I have a lot to say in response to that comment, Your Honor. But I want to say first, we believe this case falls in the first category and not the second. And their idea that they're somehow innocent as the driven snow is not reconcilable with the record.
Do you mean in the sense that...
In the sense that they are capitalizing on this opportunity.
You believe your clients did not owe the dollars and cents that were billed on these invoices?
Well, in fact, I do believe that because they did not elect in the lease to have the right to pass on those allocated costs. But that's not...
And when I asked opposing counsel, I do think there's some disagreement between you all about whether the lease in fact authorizes the emergency service fees, but I took counsel to say that we can assume for purposes of this discussion that those fees cannot be charged.
Right. I think that's right. They have to assume that for this purpose. And I think, Your Honor, we don't believe that they would ever have been legally authorized to pass on these charges. But that's not the nature of the claim.
No matter how they labeled them.
Well, I don't believe under the lease they could have passed on these charges no matter how they were labeled because they didn't contract for it. But that's not the claim here. It's a statutory claim. The reason I say our case falls in Justice Blacklock's first category is that one of the purposes of this statute was consumer protection. It was to protect tenants from opportunistic behavior by landlords. And bundling in hidden fees to hide the real cost of residency in order to justify not increasing the rent to cover those costs, but to hide what you're passing on to the tenants, that is exactly the kind of opportunistic behavior that the law ought to abhor. And with respect to the idea that it's a catastrophic consequence, that's simply not the case. We indicated in the brief, I think the potential value of this class claim is $1.5 million. When you look back at tab B, at that particular water sewer base fee that's at issue here, it's a $35.49 base fee, but bundled into that is the $21.45 basic service connection fee that is the permissible charge. And so the overcharge is the bundling of legally impermissible charges. You're talking about a fairly limited class period, one complex of 700 units. We're not talking about a $100 million case here. What we are talking about is applying the rules as they're written.
In construing those rules, should we look not only to the rule that you just referenced about charges billed for utility service may only include bills for water or wastewater, but should we also look at the rule that says that the charges have to be separate and distinct from any other charges on the bill? Does that help inform the meaning of what it means to say that it may only include these certain things?
It does, Your Honor. And I've focused on 124A because that's a particular provision that's highlighted in the summary judgment ruling. But that's exactly right, that the rule requires itemization of specific charges in order to give transparency to tenants as to the charges that are being passed through to them. And that was simply baldly violated here, and there's no dispute about it. I would like to turn to Cessor. I don't want to in any way truncate the discussion of Simeon, but if the court has no further questions about the liability issue in Simeon, I guess I'll leave you with one final observation, and it is that in my tab D, that is those interrogatory responses, the very first highlighted passage on the second page of tab D makes clear the fact that matters for class certification, which is that all residents were charged an equal water sewer base fee. This issue, this liability theory that I've just described, applies uniformly to every class member, and the defendants have never suggested otherwise. So now let me turn to Cessor and the question of what rigorous analysis requires in Cessor. Because, as I alluded earlier, I think there's a significant misunderstanding on behalf of the defendants of what rigorous analysis entails. It entails a determination of whether the class is cohesive, whether individualized issues will predominate over common issues such that it is not superior to litigate the case on a class-wide basis.
So do you think the Fifth Circuit had it wrong, that they went too far into the merits in their case?
Your Honor, Clevin was a very different posture, and I'm happy to have a chance to talk about Clevin because I think it's important to understand the distinction between the Clevin case and this case. In Clevin, it was undisputed that the landlord had not made a prospective estimate of its damages from late fees. And the trial court not only granted a summary judgment ruling that there was a strict liability interpretation of the statute, that if you failed to prospectively estimate your late fee damages, you were per se in violation. But the trial court's class certification order explicitly based the predominance determination on that ruling. And the defendant in Clevin made an argument that this defendant has never made, which was that, number one, we think that interpretation of the statute is wrong, and number two, if you don't subject yourself to per se liability by failing to make a prospective estimate, we think we have a way that we calculate our late fees that requires individualized inquiries. And that's why the Fifth Circuit said in Clevin, the key issue of predominance turned on the statutory interpretation question. Because the district court had said, I don't have to worry about the defendant's argument that there's a lot of individualized calculations to be made, because this defendant violated the statute per se by never making those calculations in advance. It's a little bit like, for those who are familiar with fraud on the market litigation, it's a little bit like the presumption of class-wide reliance. There was a rule that was regarded as disposing of any individualized issues. What the Fifth Circuit said was, we disagree with that interpretation of the statute. We disagree that failure to make a prospective estimate is a per se violation. That then leaves open the debate between the parties about whether there would be individualized or class-wide issues, and the Fifth Circuit just sent it back to the district court and said, now you can reconsider whether it's still suitable for class adjudication, and in that posture, the case then settled. What's different here is that the trial court never made such a ruling. There is no summary judgment ruling. that adopts that prospective estimate requirement. The class certification order does not adopt that requirement. Mr. Russell is correct that we litigated one theory of liability based on that prospective estimate requirement, but the trial court did not embrace that as the basis for class certification. When you look at the common questions identified in the class certification order, the court identified a series of common questions that apply uniformly. They include both the possibility of a failure to estimate damages in advance, but also, more important, precisely the interpretation of the statute that the Clevin court gave from the Fifth Circuit, that this defendant did not assess late fees that are a reasonable estimate of uncertain damages, regardless of whether it made a prospective estimate. And all those questions are common, because this defendant never argued that there was any individualized issue that could ever arise under any interpretation of the statute. They argue about rigorous analysis, but they never suggested a single argument about interpretation of this statute that would lead to a need for individualized decisions. They have essentially conceded from day one, these are all class-wide issues. The class will win or lose as a matter of uniform practice based on the resolution of those questions.
And I think that gets to the question your colleague on the other side says that this is basically like summary judgment and the defendant has no burden. What's your response to that?
Well, I think that is unworthy of the courts. It is not only incompatible with the law, but it's unworthy of the courts to say that a defendant can simply lie behind the log, just as it would be unworthy to say a plaintiff can lie behind the log. Counsel suggested that we were somehow trying to lie behind the log and take it easy. Absolutely not. I urge you, read the record of these two class certification hearings. You will see a careful, detailed analysis of every prerequisite to class certification. If a defendant wants to argue that some of those criteria are not satisfied, a defendant has the obligation to come forward, present that argument, and secure a ruling. And plenty of members of this court have been in that position of opposing class certification rulings. You know the job that is required of defense counsel. It is not to sit back, say nothing about the merits of the class certification ruling, and then pop up on appeal and say rigorous analysis was not undertaken.
Are there cases that talk about the defendant's burden in the trial court on a class certification?
Your Honor, I think that there are cases that are discussed in the briefs that deal with waiver of particular complaints by a defendant because the particular issue was not brought forward in the class certification hearing. I don't know that I can cite you a case that stands for the self-evident proposition that class certification hearings are no different than any other proceeding in any court of law. You have to preserve your complaints if you wish to complain on appeal. This defendant has no complaints about class-wide adjudication of this case.
That'd be true if there simply was no discussion in the certification order of, this one has a commonality or something like that. Would it be the case that failing to object to that would class goes forward without anything in the certification order?
Your Honor, that would be an exceptionally poor class counsel, and I'd be ashamed to represent such a lawyer on appeal. But if a class certification order completely omitted one of the requirements for class certification, and defense counsel stood idly by and never advised the trial court, you haven't addressed one of the necessary predicates for class certification, that's a waiver. I would want to disassociate myself from lawyers on both sides of that case.
But the question, I guess, turns to whether these requirements are purely, as in ordinary cases, something that can be forfeited or waived, or whether they're requirements because they have systemic value and help the courts function right. And if we have something that on its face doesn't comply with something that says must, the order must state that, is that really something that, I can see your argument, maybe it's something that can be forfeited. I can see something where maybe it's harmless error. It's right there in the other thing that wasn't signed, but we know what it was. Or maybe it's something where no, on its face, which I guess is your friend on the other side's position, like, no, we have no burden. It says you have to do it. You didn't do it, and that's that. How do we choose among those?
Your Honor, I think this court's line of authority in dealing with waiver in the context of mandatory, statutory, or rule-based criteria controls that question. And this is very much like the Geomet decision a couple years ago, where the court dealt with a mandatory stay of all proceedings. The legislature has not given any latitude for a trial court to lift that stay. The court said there's no discretion to overlook that requirement, but like any other mandatory rule, it can be waived if the party entitled to the protection of the stay doesn't assert it. The only distinction is if it's a jurisdictional issue or if it's fundamental error. And this case doesn't come anywhere close to a jurisdictional defect or fundamental error.
But there was
Fundamental error to say that the mandatory requirements of telling how maybe years of litigation can unfold are just not there in essentially the organic document for a class action litigation?
I think not, Your Honor. Okay. I would be shocked if a court anywhere would say it's fundamental error to fail to comply with the particular requirements of the rule of procedure. Happily, we don't have that here. You have a very careful, very detailed class certification order that comes on the heels of a very thorough class certification hearing.
So there were some, they did of course oppose class certification, and there are some decisions that say that that's enough to preserve certain kinds of errors, just totally opposing class certification altogether without pointing out the specifics. Would the failure to mention the limitations defense in Simeon fall within that category? Because it was in their pleading all along from what I understand. So why didn't the trial court include that in the trial plan, and should we send it back for them to look at that?
Your Honor, I think first of all, the answer is failure to bring forward a opposition to class certification at the time the motion for class certification is asserted, and failure to make that argument at the hearing is a waiver. The fact that a party pleads a theory of recovery or a theory of defense doesn't absolve it of the obligation under Rule 33 to preserve its complaint. But it's completely immaterial here because the Simeon class period is entirely within the 2-year limitations period that the defendants say is applicable.
I saw your argument on that, but are there any cases that apply that kind of harmless error analysis to failure to include a defense or something in the trial plan?
Well, Your Honor, I think the court has said that the harmless error rule applies to all sorts of errors other than fundamental errors. But more practically, this limitations defense cannot affect the claims in this case under any circumstances. The class period is subsumed within the 2-year limitations period. And so I would submit that the really technical answer to this is that the trial court solved for the limitations issue in the class definition because the class period eliminates any question about limitations from this case.
Any other questions? Thank you, Mr. Post.
Thank you.
Mr. Russell, I believe you have 8 minutes.
Thank you, Mr. Chief Justice. I want to start with about 4 points, and starting with class certification and work my way back to the merits of the Simien water code issue. So first of all, I was trying to get into the discussion, Justice Bland, with you about the different kind of merits issues. Council keeps taking this position on class certification that there's nothing wrong with having a class certified that falls or fails or prevails. There's nothing wrong with that. And I think that's wrong when the failure is about a question of merits as a matter of law versus merits as a matter of fact. So in other words, you can't have a claim that is certified and that is tried that fails on the merits as a matter of law versus one that simply fails as a matter of fact. An example would be in Cessor. If we tried this case and the jury says, we just think this fee is reasonable, you lose, plaintiff. There was certainly nothing wrong with a class that ultimately failed because it failed on the merits based upon a factual determination, which is what the issue was in Amgen. But when a claim fails on the merits at trial because it never should have been certified as a viable class, which was the issue in Peak, which was the issue in Gill, then that is always an abuse of discretion to have certified that. Because think about it, you could be certifying this, what I believe is a flawed legal theory under the water code in Simeon, and there could be actually viable water code claims. Maybe there was a month where we actually did include a late fee for some group of tenants, and their claim is now barred by res judicata because the plaintiff the class representative and its counsel proceeded on a flawed legal theory. That's an abuse of discretion, and this court has reversed a claim certified on a misunderstanding of law in Gill, and it should do the same in that water code, in the water code context.
There should never be a class certification in any case in which summary judgment for the defense is legally required, ever.
Yeah, I mean, you can imagine first of all, it's only the plaintiff moving. I mean, I guess theoretically a defendant could move for class certification. I just won summary judgment on this liability that was a flawed legal theory based upon undisputed facts. And let me go certify that so I now have a final judgment that creates res judicata for all these potential defendant or potential claimants out there that would have brought the same legal theory or would have qualified as a member of the class. I tried to find one. There isn't such a case because only plaintiffs move for class certification. And again, it's always an abuse of discretion to certify a class that's based upon a significant misunderstanding of law, not some minor misunderstanding of law, but one that goes to the heart of what the claim is for.
It looks to me like your interrogatory responses may have conceded that even if these fees are what you say they are, they were all charged in the same way to all of these people, and so there wouldn't be a typicality problem with with doing this as a class, even if you're right about what the fees represent.
Well, the interrogator was just answering the factual question about what was included in the fee. It wasn't really.
And it says everybody was charged the same fee, and so if you're right about what the fees represent, that they're for these other charges that were owed, do you have some argument that creates problems for class certification because it requires individualized analysis of everybody's different situation?
It certainly could be, and we would argue that if we ever got to a point where there was a class certification on a valid claim. We would be arguing those types of issues. But we don't even have a valid claim here, so just like in Cleveland, you don't get to those next steps in the analysis.
But you're trying to defeat class certification with a theory of what an overcharge was and what these fees were, and I'm trying to understand how your legal theory of how the statute works and what these fees were for maps onto the class certification factors.
Right. Well, all we've argued, and this is why we rested on this and argued this in response to both motions to class certification, is if you misunderstand the law or you don't even analyze the law in a demonstrated fashion, which means it's in the order itself, which is the case in Cessor, then you have not done the rigorous analysis, or maybe you've done some rigorous analysis, although in Simeon not demonstrated in an order. You look at the summary judgment order, it just says granted. There's no analysis about why it was granted. But under either scenario, it's a invalid class certification. It doesn't mean, like in Yarborough, it can't come back and be properly certified once you've done the analysis, but then you might have a situation like Cleveland where you've done rigorous analysis. We don't dispute the federal district court there did rigorous analysis. It just turned out that analysis was wrong. So you decertify and let the court reconsider those prerequisites, understanding now what the statute actually means. But I want to get to the merits real quick because it goes to the heart of your Honor's question, which is, think about this on the merits of the water code claim. If these fees for the combined, what I think is a customer service fee in the MUD rate order and the fire, EMS, and law enforcement fees, all of which are per unit charges, if they'd been spelled out, they would have no water code complaint, right? I mean, they're not complaining that we got charged. Now, as far as the water code goes, they're complaining, they say it's not permitted under the lease. I'm not sure exactly what your Honor's question was about the presumption, but let's assume that it was or wasn't. It doesn't matter whether it was valid under the lease. But the question here is
about... If it's not valid under the lease, it seems like it's no different from just doubling the charge that the MUD made to you.
No, it's not doubling at all. We literally get charged.
I understand you're not doing that. This is a hypothetical.
Okay, all right.
So, in one situation, I'm looking at the MUD bill here, and it says water, sewer, law enforcement fee, service charge, the connection charge, fire, and EMS, and all of those are itemized. And in a hypothetical situation, if a defendant just took that and multiplied it by 2 and put it in the bill, I think you would concede that's a violation of the water code.
No, I think it's a violation of the lease because you're doubling what you were actually assessed for government service emergency fees, not.
Well, one of those things is the service charge, and others are water and sewer, so those are regulated by the water code.
Well, okay, well, the service charge maybe, but again, they're not complaining about the service charge. They're not,
Right.
it's literally taken out. They're only saying it's the fire,
What they're
EMS, and law
saying is
enforcement.
that you were billing this as if it was the service charge and including other stuff in there.
But I don't think that's their complaint. Their complaint is it is a violation of the code because it relates to utility costs, not because it was bundled with something that might fit within utility costs. And that goes to the second way.
I thought their complaint, just to be very precise about this, is that it was imposed for utility costs or billed for utility costs.
I mean, maybe, but that goes to the second way that this court can dismiss those claims under Spokio. I mean, they're not complaining that we, in substance, charged them an excess amount of actual usage charges, like maybe some of that 25% or one of these expressly prohibited charges. They're simply saying, in my hypothetical about, describing the itemized fees as some other water-related sounding fee, I mean, they're not complaining about the substance. They should have been breaking open the champagne bottles instead of breaking open a motion for class certification when they found out, oh, we're only paying for a fee that we're happy to pay for because we certainly want fire, EMS, and law enforcement. So it was just the
Except
format.
that if they couldn't be charged for that under the lease, they might not be happy. But I'm not sure why Spokio is relevant here because they are out of pocket. And I mean, they have paid money that they say they shouldn't have had to pay. So why isn't there standing?
Yeah, well, because it's not that they didn't pay money, no different than the example of, I think, one of the Southern District of Texas cases applying Spokio, that the charge is legitimate, putting the lease issue aside. The charge for fire EMS is legitimate to be passed along. They're not complaining about that. They're complaining about the description of it. And that's exactly what TransUnion versus Ramirez talked about. You're not harmed by the description. You would be harmed if that description caused some concrete harm. Here, there's no concrete harm. There was no extra water-related fee. There was no expressly prohibited late fee, disconnection fee. It's an unrelated fee that only caught their attention as a potential water code liability for overcharge because it was mislabeled.
If it can be charged properly under the lease.
Assuming it could be charged properly under the lease. And for the reasons we argued in the brief, we think it absolutely was.
Any other questions? Thank you, Mr. Russell. The case is submitted, and the court will take a brief recess.
All rise.
Please be seated. We'll hear argument in 2980, Wal-Mart versus Xerox.
May it please the court, Mr. Melkonian will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. This case, fundamentally from our perspective, is about whether Xerox may escape any responsibility for its own negligence and breaches of contract in allowing the crucial EBT system to go down for 12 hours on a busy Saturday in October 2013. As we'll hear from my friend on the other side, Xerox's theory is that Walmart's only way to protect itself from Xerox's negligence was to stop selling food to SNAP families. That is not what the what the regulations require, and it's not what the regulators want, and it's not common sense. The judgment below should be reversed. My plan is to start talking about the regulatory framework, why the Court of Appeals got that wrong, and how that causes the summary judgments to be reversed. And then I'll go to the individual causes of action, though, of course, wherever the court would like me to go, that's where I will go. So with respect to the regulation does not mean what Xerox wants it to mean, that they have immunity for any act, whether negligent misconduct, recklessness, fraud, or anything else, in the context of store and forward. What it means from our perspective is that Walmart cannot recover against beneficiaries of SNAP in a store and forward transaction. And we have several reasons why that's so. And
Could it also mean, though, that Walmart is on notice that the program allocated the risk of loss to it rather than to the government's vendor in choosing to sell during an outage? In other words, could it inform the duties and obligations, even if there's no immunity or preemption, it could inform the duties of the parties in terms of risk of loss?
I think theoretically it could, Your Honor, but it doesn't in this circumstance, because I think the text of the regulation alone and the history and context of the regulation suggests strongly that what the kind of risk that's being allocated to us is the risk that there's a outage that's not a cause of negligence, that's not caused by negligence, and then we can't recover against the beneficiaries for the money we lose. There is nothing in the text of the regulation that suggests someone like Xerox is even contemplated by the regulation, or that the duties of someone like Xerox is being allocated. The entire regulation is premised on the question of, can a retailer like Walmart recover against the beneficiary, and in what circumstances?
So your position is that it would not inform liability at all. If we went to a trial in this case, the jury would never hear about this regulation.
Well, they may want to use that as a sort of defense. I mean, I think we would object and say it's not relevant. I can't know what the trial court would do with that. But our position would be that it has nothing to do with whether they have duties to us in tort. That's right. Whether it gets presented to them or not, I can't say. Now,
if we agree with you about what the regulation means, does the Court of Appeals misunderstanding of that sort of infect all of this and send us in the direction of a remand so that this can be reconsidered without being infected by this misunderstanding of what the regulation means?
Yes, Your Honor, but there's two buckets to think about. The first is the first motion for summary judgment. That applies to the 30,000 transactions that were denied for the invalid PIN or the insufficient funds that were in the count. Nothing to do with the invalid codes that we can talk about later. Now, with respect to those, if you look at the Court of Appeals opinion, the only thing the court says is it's the regulation that allocates responsibility to Walmart. And so I think if you agree with us on the reg, then that's automatically reversed. There's nothing else to do about that. With respect to the second
Was
bucket...
that the only ground in the trial court for the first summary judgment, the motion for partial summary judgment on those particular claims? Was
We believe it
regulation
was.
the only ground?
Yeah, we believe it was, Your Honor. That's the ground that they pressed. I'm not sure what Mr. Cole will say about that, but we believe that was the only ground presented.
So if we agree with your construction of the regulation, we reverse that partial summary judgment as to those 30,000 claims, but we remand Because all we're saying is they're not entitled to summary judgment on that ground. They may yet be entitled on another ground.
Absolutely, Your Honor, and we're perfectly happy to litigate all the grounds, when we get back to trial. As to the second group of 50,000 transactions, that's the subject of the second motion for summary judgment. There, we think that does infect, the regulatory misunderstanding does infect every part of that decision, but the Court of Appeals does also say other things. And so we think you have to perhaps, you probably don't have to get to those other issues, but we think you could theoretically do that. So with respect to negligence, for example, the Court of Appeals says they have no tort duty to us. That one, I think, is premised entirely on the regulation. But then with respect to negligent misrepresentation, the Court of Appeals says, yes, it's the tort duty problem again, but also they concentrate on the testimony of Mr. Howarder, who says, look, Mr. Howarder is a Wal-Mart employee, and he says, no one literally told me to send all the transactions over to Xerox at this time. And he's talking about a particular time during the day of that outage. And our position there is that Mr. Howarder went on in his testimony, and he said, that's because no one does that when you're doing these kind of electronic transactions. What happens is that Xerox flips open a switch, that's called the mini switch, and that is an indication to the retailer that the system is ready to process transactions. So that's a negligent misrepresentation from our perspective. But also there's negligent misrepresentations with respect to Xerox's statements that the system is coming up, and they keep saying the system is coming up in 30 minutes. What that causes is Wal-Mart to stay in store and forward mode in reliance on its belief that the system's about to come up. If they had told us, by the way, we are refusing to switch over to our backup system, and this is going to be down for 12 hours, and you're going to have tens of thousands of failed transactions, we may have certainly had a different view about continuing in store and forward.
I thought your position was that it was not feasible to call the state on all these customers.
Exactly right, Mr. Chief Justice. But the alternative they would have us do is simply stop selling. And that is an alternative that's permitted under the regulations. But it's not the alternative the regulators would want. And it has pretty severe consequences for our customers. I mean, we're talking about people often who are disabled, or they have transportation problems or family issues, and they're in the store with a full basket. And what Xerox wants us to do is turn them away. And we don't think that's the right answer. Indeed,
There is a reimbursement process, correct? So, but in this case, the USDA denied reimbursement to Wal-Mart.
Well, Your Honor,
Does that have significance in terms of looking at the other summary judgment grounds that were put forward aside from the preemptive effect of the regulation?
Your Honor, we actually think that USDA determination helps us rather than hurts us, and let me explain why. First of all, I just want to make a factual point. That letter that my friend on the other side relies on is in reference to a completely different incident, a 2015 incident involving JP Morgan. So it has nothing to do with this case. They're using it as an example of USDA saying, we're not allowed to represent, which is the technical term for that, when there's an outage. But the reason it helps us is that it shows the regulation is limited to reimbursements against beneficiaries. They're saying, look, this was at your own choice and liability. You can't go after these people for money that's in their account now. And we completely agree with that. That is how the regulation works. But that letter does not say that Xerox is immunized from all liability, or that you have no other remedies, or you can't do anything about it. That letter is just exactly consistent with our theory of this case. So no, I don't.
Section 274 seems to allocate responsibility to a lot of these different entities, the third-party processors, all these characters. And so when in 274.8E it only talks about the retailer's own choice and liability, why can't we take that to mean something? If that was a conscious choice to not allow liability to be expanded to others like Xerox or others?
I think two answers to that, Your Honor. First, I think if you were doing the kind of immunity that Xerox wants you to do, first of all, you run into my preemption argument that we've made in our brief. And so that's a serious problem. We can talk about that. But also, I don't think those are the words you would use to create blanket immunity for even fraudulent misconduct, which is what Xerox's position requires. I think you might say Wal-Mart or the retailer has sole and exclusive liability. No other party shall have liability for any reason. You might even use the kind of words that we heard in Ray Academy that was decided a few terms ago. No cause of action shall be maintained for any claim relating to liability arising from a store and forward transaction. But none of those words were used. This just says no choice in liability. And so the court's task is to figure out what liability means in this particular context. And I would point the court to the last sentence of E1, which is the sentence that explains the exception to the general rule. So the general rule is own choice and liability, and then it says sometimes you can recover against the beneficiaries in this circumstance. So that is an indication to me of what liability means in the first sentence. And then if you go back to E2, that's the next subsection, it says there's some more exceptions for how you can recover against beneficiaries, and that's as the states might allow in certain circumstances. So I think if you're reading liability in general, I understand their argument, of course. That word seems broad. But in the context of this particular regulation, and then when you pair it with the history and context of the regulation, I think it becomes clear, at least to me, that liability has this more limited meaning. And then again, we have our preemption problem, where if it is what Xerox wants it to mean, then you've had the federal regulators without any statutory authority whatsoever. The statute that creates SNAP does not say, by the way, we want to immunize people. So without any statutory authority, they're creating a broad immunity for people who aren't mentioned anywhere in the statute. And I think that would be inappropriate. It's another clue this court can use.
It may not create immunity, but does it demonstrate that Wal-Mart is not an intended third-party beneficiary, in connection with this program?
No, I don't think it does, Your Honor. And the reason I don't think it does is because the contracts themselves clearly contemplate liability to the retailer and Wal-Mart. Now, my friend on the other side has 6 contracts that have no third-party beneficiary language. There are 10 where they're just not in the record at all. Those parts of the contract aren't presented. And I think that's just a fundamental problem. But even those 6, and the 3 he has in his bench book, all of those incorporate the Quest rules. And the Quest rules have a specific provision, section 10.3, that contemplate an indemnity to retailers in the scenario of negligence or fraud, that's one of the subsections, or malfunction, which is exactly what's going on in this situation. So I think what this regulation creates is a default that with respect to the internal workings of the SNAP program, Wal-Mart can't recover against the beneficiaries, but then it allows other ways to recover against other parties in the system. And one way is contract. And we think the contract here contemplates indemnity to Wal-Mart. By the way, those indemnities are capped in most circumstances. So I know there's this undercurrent in my friend's arguments that, we could allow a bonanza where people come in and buy all kinds of things and then they're on the hook. That's not happening.
There's some indication that happened at least at a couple of stores.
It happened and we stopped it. At least that's what's in the record. There's not a ton in the record about it. But if that happens, that's our problem in many circumstances because these indemnities are capped at $40, $25. And indeed, if there wasn't any negligence, we wouldn't have these tort claims. So in that circumstance, there's a very strong incentive for us to stop any kind of overbuying.
Just to be clear, I asked earlier if we agree with you that the own liability language does not preclude liability by Xerox, then we have to reverse, but we should remand on the first summary judgment. If, on the other hand, we conclude the own liability language precludes liability by Xerox, we agree with the respondent here, does that only resolve the first summary judgment? Or does that also resolve in this court the second summary judgment? In other words, in the trial court, was the regulation a ground for the second motion for summary judgment?
It was a ground that was presented, but I think if you go to the Court of Appeals opinion, with respect to at least breach of contract, it would not resolve that, because what the Court of Appeals says for breach of contract is you don't have third-party beneficiary rights. One thing it says is the reason we think that is because the regulation, puts harm on you, but we think that wouldn't entirely resolve it. And we think that would also leave open the negligence and negligent misrepresentation claims at all, because that's not the only ground the Court of Appeals set forth.
Well, and I understand the Court of Appeals, but what really matters is what was the ground on which the motion was based in the trial court, right? Because if there's any other ground that would support the summary judgment that was presented in the trial court, then we would need to affirm.
I think the answer to that question is that there were other grounds asserted in the trial court, but the Court of Appeals only chose one of those grounds on which to affirm, or some of those grounds.
Any other questions? Thank you, Mr. Malconian. We'll hear from the respondent.
May it please the court, Mr. Cole will present argument for the respondents.
Fittingly, I'm waiting for the technology to catch up. Hopefully we won't have an outage. May it please the court. The problem here is not one of interpreting this regulation. It's more fundamental. Wal-Mart just doesn't have a claim against us. You can call it tort, you can call it contract, but we don't owe a duty to them, and we didn't cause the damages that they're trying to recover in this case. My exhibits that I offered to the court yesterday highlight what I'd like to begin with before discussing some of the doctrinal points and points about the record, which is the structure, not of the regulation, but of this business. On the one side, you have the American taxpayer, USDA, Federal Benefits Program. It, in turn, contracts or works with state agencies to give money to those who need this money, the SNAP food stamp program. And those agencies, in turn, contract with experts in the IT field, such as us, to go through the computer systems and make them work and handle the day-to-day operations. So you have money, federal money, state money, IT for the states over here. Then there is a gap, and you have over here now at the people who get the money. This side's the givers. Taxpayer gives to the government, goes on down and through the computer systems to the ultimate people that will spend the money. But here on this side, you have the receivers of money. You have the retailers, the Wal-Marts of the world that handle thousands upon thousands of transactions every day. You have mom and pop at the corner. There are hundreds of them all through this state and these other 16 states of all different sizes. They, in turn, hire IT professionals to help manage their systems and make sure all these cards are processed correctly, all the money goes to the right places, and they have contractual relationships and understandings with them. It's like buyer-seller. It's like it's giver-receiver, whatever analogy you want to use. This is the classic adverse relationship in commercial law. One side is giving money, one side is getting money. Both sides have people on their team. They're the agencies that in turn use other agencies that in turn use their IT people. On this side, you have the retailers who use their IT people. What this regulation says, and Justice Bland, I've struggled with a name for it. When you said it's sort of an acknowledgement, I tried to think of a catchy name, and I couldn't. The best name I could come up with for a doctrinal label to put on what this regulation says is reality check. It basically says when you get into this program and you elect to use store and forward, don't forget, Wal-Marts of the world, that this business relationship exists, that you've got your own IT people on that side of the equation, that side of the gap, and you need to get your act together with them for this program to work as speedily and efficiently as it needs to work to do what needs to be done.
What were their IT people supposed to do to countermand the 10 hours and all that?
They could have correctly transmitted the information that we sent them. I mean, we sent them thousands upon thousands of codes, and this is the glory of information technology. You can have, enormous roomfuls of this information, but we sent code after code after code that said, resubmit later. There's a temporary problem, and every single time they changed that code to one of different set of codes, but a code that meant throw it in the trash. So they could have programmed them correctly.
I hear you saying that your client should win because it did everything right and they did everything wrong, but I don't think that's what's before us today.
No, it's not.
You're not
No.
conceding, are you, the regulation argument that's been presented in the briefs?
I think, no, of course not. The regulation is informative. The regulation sets
Do you
the...
think it on its face immunizes and precludes any claim against Xerox in this case?
I think what the Court of Appeals did with it is exactly right. It said this regulation, as to the risk of not having funds, clearly allocates that risk. That risk is off the table. As to civil tort liability or common law contract liability, it's a relevant consideration. And what the Court of Appeals did was look at the criteria you look at for an implied contract, the criteria you look at for...
It's not your position that the regulation immunizes Xerox against the breach of contract claims that have been asserted in this case?
No, I think it makes it impossible for them to meet their burden of an implied third-party beneficiary.
But it doesn't immunize.
It's not a magic wand that we wave at the top.
But then as for the first motion for summary judgment, dealing with the insufficient funds and wrong PIN, do you think it immunizes and precludes any claim against Xerox for those transactions?
Yes, that was the basis of that summary judgment, and that's crystal clear in this regulation. There's room to argue, remember there's a lot of people in this pyramid, about whether or not they were thinking about liability across the lower levels of the structure, but at the top, on that risk of non-payment, no question, they immunize that. They say, look...
So if we disagree with you, then is there any other ground on which we could affirm the first summary judgment order?
So...
Currently in this court?
So the first motion is based entirely on the reg. The second has a number of other grounds.
So there's not another ground on which we could affirm the first order?
That's it. We got into all of these grounds sort of met each other in the motion for new trial briefing. I mean, they sought a new trial on the entirety of the summary judgment orders. We countered with the full panoply of issues, and frankly, the lines as of the final judgment weren't all that clear. I'd also suggest if there's no cause of action, there's no cause of action. And if, in fact, on reviewing the second set of claims, and you conclude there's no viable contract claim, there's no tort claim, well, there's not a viable contract claim or tort claim no matter what the first ground may be, whether the regulation is extra. In that context, I don't think it's a meaningful distinction, given the nature of the specific grounds. So this USDA letter is a good example of this operation of this structure and some of the concerns that we have, what Wal-Mart did with its system. Why were they doing that? And why were they changing the codes that we were sending them, resubmit later to throw it in the trash? And our expert report goes through that. It had to do with a strategic decision Wal-Mart made about kind of getting in line faster when the system came back online. And they concluded that throwing sets of claims in the trash helped them get back in the game quicker. That had benefit. They did it once, they did it twice. The USDA in their letter says stop doing that, and they kept on doing it. They did it a third time in this case. I doubt they do it anymore. But there is, that shows the operation of the distinctness of the two different sides of this. They have their own reasons for doing what they do. They're free to do that. I mean, if they want to throw some claims off to the side and double down on one way of processing claims, they can try to make some more money, power to them. That's their right. But that doesn't make us their guarantor or make us responsible for that. That's a decision they make with their data person on their side of this business relationship.
Is that a complete answer to Mr. Malconian's suggestion that what you really offered to Walmart was stop selling to people in the SNAP program, or does it not quite get forward?
They could have, well, stop selling is certainly one option, particularly when mobs are running in with grocery carts, which the record doesn't have a lot about that, but it has some. But yeah, if their system had run properly, we wouldn't be standing here. There might still be some injury, some damage, but we wouldn't be talking about a $1 million damage claim. They would have had a system that correctly heard, submit later, and they would have done something with that that would have actually been a store and forward proper request, but they just didn't do it. And that was the basis for the primary basis for the second summary judgment, in addition to arguments about the lack of duty and whatnot, was this expert analysis that went through code after code and said they're just changing what you said. And so I think that if the facts of this were a little different, the equities might look a little less favorably on our side, but when they systematically changed everything that we told them, that's just on them, and that breaks the causal chain in tort, contract, and everything else.
If their system had run properly, in your view, and you sent them the wrong code, would you be liable for that?
So if they weren't changing everything we said, and we had sent a mistaken code on the front end, be a more compelling case for sure, but we'd have to go back and see what would the claim be. Is it a claim in contract? Is it a claim in tort? We don't have a contract with them. We have a contract here. They've got First Data, who's supposed to check for that kind of problem with data. Okay, well, is there a tort claim? Do we have a duty in negligence? I suppose it would perhaps go to how many codes there were, the nature of the error, or something like that. But it would be a hard sell, because there again, while the contract makes it very clear, tort's a little more fluffy there, they've still got their own IT person that can look to see if they're getting junk information or not. So it's possible. I could see the argument better, but it would be greatly uphill, I think, either way, just given the nature of how this works. Continuing on the question of what is the cause of action, it's contract or it's tort, it's one or the other. Is it contract? It has to be third-party beneficiary. We don't have a contract. There's no question about that. This gap is complete when it comes to a direct contractual relationship. And it seems a little odd that you don't have, I mean, we've all seen the classic breach of contract pleading. You breached the contract, Exhibit A is the contract. You're the other party, you owed me these duties, give me my money. They don't have that. In fact, they don't have the contract. The best they have are some snippets that we see in the reply brief and a reference to these Quest rules that are a set of industry standards that some states use and some states do not. But here the Court of Appeals, again, got it exactly right. It looked at the Quest rules, and there is a specific statement in them that closely tracks the language of the applicable federal regulation and says, that's on you. That's your risk. And yes, there is general language at the end about indemnity. Everybody has some sort of obligation against somebody else, but specific controls over general, that's it. Now, whether that gets you to third-party beneficiary status is a whole other question. I mean,
So in your chart where you've got the USDA on one side and the retailers on the other, you don't have the consumer, the user, that's in the interface between these two.
There were so many of them, I couldn't draw them all in.
Is it their theory that they ordinarily would be able to recover against the consumer, right?
Right,
for
the nature of the program.
And so is it their theory that they come up to your side as an intended third-party beneficiary that way? And why is that theory?
So they know that they're not going to get the money from the person ever, because that's why they're in the program, is they have an income problem. So they're always going to be paid by, when you run the card, you know you're getting the USDA's money. So there's a relationship there, and there's an understanding of what the USDA and retailers are going to do with one another. But then you start looking down the list. And so if we work for the USDA and or the agencies below them, make their computers work, does that become a contract with Wal-Mart? That's a tall order. I mean, I can see where could we do things that benefit them? Certainly. We could run our computers in a way that would help them. We could run our computers in a way that hurts them. But that's not our duty under the contract. Our duty is to run our computers in a way that makes the agencies happy. We work for them. And we really don't have any obligation to consider what Wal-Mart's interests may be, except insofar as it runs through the USDA. That's classic incidental beneficiary stuff. That's just trying to inject us as the subcontractor into that relationship, makes us serve two masters, and is the reason why we don't like incidental beneficiaries. It puts you in an untenable situation. Incidentally, the other indemnity provisions that are cited in the reply brief, again, I don't think they get to the level of incidental beneficiary, but they are from provisions in bid documents submitted in connection with this program relating to manual transactions, which of course are not part of this case. Wal-Mart was never going to do that. They're not seeking damages based on that. It's just not something, it's something that might be relevant to a smaller store, but a company of the sophistication and size of Wal-Mart simply was not going to do that. So those have really nothing to do with the contractual relationship at all, much less the contractual relationship that would rise to the level of an intended third-party beneficiary, something other than an incidental beneficiary. A couple of comments on other specific claims. The Court of Appeals, and again, when I say the tort claim, every time in some way they work in the concept that I was talking about with Justice Bland, the reality check. We get to this tort, remember the risk is on you, and the regulation is kind of a shorthand for the overall structure of this whole thing. Negligent misrepresentation has gotten some additional treatment in the briefing because there was some testimony about it that was sort of unique to that claim, but there's nothing unique about it as a claim. The same problem is there about the structure of the businesses. There would still have to be a duty that spanned that gap somehow. The same problem is there with the codes. They're still changing everything we say, no matter what we say to them on the phone. Their computer system's still running in the background, scratching out all our 19s and turning it into goodness knows what else. And that's the end of that before you ever get to that testimony. There is then some discussion about whether there's yet another ground for summary judgment based on whether or not we ever even said anything to them meaningful. And the evidence there, we cite this in the brief, we don't go through all of it except for the flashy soundbite, but it's a couple of different witnesses corroborated by transaction logs. You know, everything these people do is logged, and if you study that, you'll see that there's no basis for the claim of representation either. Now, the stakes, in this case, this is a commercial dispute, two large companies, but the evidence in this record, and this is not idle speculation, this is evidence presented to the trial court when we argued about contract construction and scopes of duty, is this really matters. This separation between the two sides of this business relationship to the Xeroxes, to the contractors of this world. Mr. Froderman's affidavit says it's just not going to work. People just aren't going to do this and contract. If instead of a risk here, you serve all these retailers out here, it's not just Wal-Mart, of course. You can't have a Wal-Mart-specific rule. There are thousands upon thousands of these retailers, any of whom could have whatever problem they may have someday. They'll come looking for you. We can't do that. We can only serve one person at a time, and the same is true for any rational actor that would enter this space. It's also discussed at the end of our experts report. It's page 793 in the record. It goes into a little more detail about how the industry expects this to operate, the industry being the data processing industry that we are part of, and why this would be contrary to those expectations. Is Wal-Mart left penniless here? They are, of course, not. The most obvious solution that would have avoided this whole problem is if they had properly programmed their computers and not changed what we had said to them. But there is really not a practical risk.
But another solution, right, would be for them to just wait to send the information to you until the computer system was up again.
Which is what they could have done had their codes been processed correctly. We were telling them.
No, I'm talking about before they ever send them to you the first time. Because they say, well, you told us to send them too early with the mini switch and that kind of thing. But that would have been another way to avoid this, right? Is if they had never sent them to you the first time and gotten the code that you said was changed, they only got that when they sent it the first time when the system was down, right?
Right. That goes down the rabbit trail of a lot of different codes at that point in our experts analysis. But you're right. There's more than one way to run this railroad.
Well, and another way to do it would be for y'all to have turned on your backup system.
There's discussion of that in the report as well. There's discussion of whether or not Wal-Mart was using the backup system. It doesn't make any difference, though. If all the codes are being changed, it doesn't matter how many backup systems are on. We could have sent them millions of codes.
But it would have been in your system, so it wouldn't have mattered what they did with it on their end, right?
No. We could have had our system, we could have instantly turned our system back on, sent the codes that we did, and they would have, well, if this, you're talking about could we have switched the system back on? I don't know what the record shows on that. There is expert analysis about that. That's not the basis for what their model is. They say, here's what the damage is in the world that we were in, here's what should have happened, and the difference between that is the way these codes were processed.
I thought there was evidence that there was a backup system on your side.
Yeah, there's discussion of that in the expert reports. It's analyzed in the summary judgment briefing. That was not the primary issue that was in front of the court, nor is it the primary issue in the way these parties conduct themselves. If there was a problem here, a bigger problem, if our systems just didn't work correctly, of course we wouldn't be able to contract with these government entities. There would be repercussions. There are checks on rogue actors and that kind of thing that are separate and apart from the civil justice system. This just isn't a claim. It's just not something that is covered by tort or covered by contract. There's not a duty and there's not a contract. The regulation is helpful background. It's explanatory. It's a powerful statement. It's dispositive on certain claims, but at the end of the day, there's just not a claim here, no matter how much we talk about the regulation. The fundamentals are not present here.
In 274.8E, the reference to host, is that you or First Data or somebody else? The retailer may forward the transaction to the host one time within 25 hours when the system again becomes available.
Yeah, I don't know. The term is in the expert report where all the pictures are, the page that we have in the handout. That discussion defines exactly who the host is, and I don't want to get it wrong.
For purposes of this
regulation, yeah, it defines it exactly there, and he uses a lot of technical words that I'm not going to get right. But off the top of my head, I don't want to get that wrong. I can just refer you to that page before and page after is where you'll find that answer.
Any other questions? Thank you, Mr. Code. Melconian, you have 5 minutes.
Thank you, Mr. Chief Justice. Let me go straight to this codes issue, because that seems to be my friend on the other side's main counter-argument. He seems to have retreated from the regulatory analysis to some extent. That codes issue, at most, is an issue to be decided at trial. We also have an expert report. And our expert report, this can be found at 483 of the first volume of the clerk's record. It's a report by Ms. Maria Arminio. And Ms. Arminio says that they're the ones who are sending the wrong codes. They're sending the code to tell people to re-swipe your card. And that, in the context of a store and forward transaction, is a nonsense code. Because especially where you're dealing with a 12-hour outage, the customer is long gone. No one can re-swipe anything. And so when that incorrect code is sent to us, to First Data, that gets misinterpreted by First Data and sent to Wal-Mart. But that isn't our fault. That's their fault for having caused the outage in the first place and for sending a code that has no application to store and forward.
So your view is that you've raised a fact issue on producing cause?
Absolutely.
And so that the trial court summary judgment, if it was granted on that basis, a second summary judgment, it was incorrect?
That's right, Your Honor. And they can bring that up as a defense if they want to allocate some of the fault to us at trial because they think our codes are wrong. That's fine. We're perfectly happy to litigate that at trial. But that has nothing to do with what the regulation says or what the basis of the Court of Appeals opinion was, in truth, because that is just the disputed issue of material fact.
On the third-party beneficiary issue, I wonder whether we need to step back and think about and sort of be careful in the way that we conceptualize what these programs are doing and why they're doing the things they do and who they're doing it for. And perhaps we should be particularly hesitant to conceptualize a program like this as existing for the benefit of the vendors. I feel like people might, you go to DC and the look at who's lobbying for what. You can see perhaps the way the sausage is made that the vendors have a deep stake here. But for a court to say that the SNAP program exists and the government's operation of it through Xerox is done for the benefit of people who sell food as opposed to for the benefit of people who need food, it strikes me as an odd way of conceptualizing what's going on here.
That's fair enough, Your Honor, and I understand the concern there. But I will say that these contracts have specific indemnity provisions that run to us. They say they run to us. And indeed, let me point you to an email in the record that's at the second volume of the clerk's record, 2477, where a Mr. Halter, who works for Xerox, on the day of this meltdown and disaster, as they call it, says, we have contractual obligations to our retailers, and we're going to be asked to pay those. They're capped. He talks about the caps, and they don't apply in every state, he thinks. We can have a dispute about that. But the fact that, in general, the prime beneficiary of the SNAP program is the SNAP recipients does not alter the fact that these contracts have very specific language that gives us an indemnity in exactly these circumstances. And that's how the whole system is contemplated. You have the system here that goes between the beneficiaries and the retailers, and then for the sophisticated parties that we're dealing with in this case have made contractual arrangements between themselves. And we think that those should be honored, as Xerox itself recognized on that day. The other thing I want to point out on this Froderman affidavit, we haven't really talked about it. The fact is the entire record of these contracts is not in the record at all. There's only snippets of each contract. And I fundamentally think that if this court agrees with us with respect to the regulation, you could essentially stop there. You could say the regulation does not mean this broad thing that Xerox says it means, even though they've backed away from that today. In the briefing below, they said that it immunizes them no matter what. It doesn't mean that, and therefore reversal and remand is necessary. And with respect to the contracts, this court doesn't even have to go to the third-party beneficiary question. It could say this is premature to decide this on an incomplete record.
If the whole contracts needed to be included, why not follow something like the rule of optional completeness and introduce them?
Your Honor, that's certainly an option. We understand that. But the one thing I'll say is that we are not signatories to this contract, as my friend on the other side will remind us continually, of course. And we don't have the contracts. Well, they have the contracts. And that's the point this court made in Paragon. It said that the party that has the contracts is the one that has the obligation to put them in. If you don't have the contracts, you can resist summary judgment on less than that. But I don't think you can get summary judgment when you have the contracts without introducing them.
Any other questions? Thank you, Mr. Malconian. The case is submitted. That concludes the cases set for argument this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.